Hello, it's Toronto immigration lawyer Max Chaudhary, and I wanted to discuss an issue which comes up for people who have acquired either protected person status in Canada or obtained permanent residency by becoming a refugee. The process I'm speaking of is the cessation of refugee status. A refugee claim that is successful can be a huge relief because you no longer fear being returned to the country that contains agents of persecution. Such persecution being meted out on the basis of race, religion, or being part of some other identifiable group. However, what if you apply for permanent residency after being deemed a successful refugee, and thereafter you have to suddenly leave Canada to return to your country of citizenship? And what if you thus apply for a passport to leave to return to your former country? This obtaining of a passport may happen due to an emergency, such as an ill relative or the passing away of a close family member. In order to facilitate entry to your country of citizenship, you may thus approach the country's consulate or embassy to obtain a passport to facilitate entry to the country from which you are fleeing persecution. This is an issue because under the Immigration Refugee Protection Act, specifically at subsection 108 sub 2 subsection A, considers such a passport application to be the same thing as giving up your refugee status. A protected person who approaches their consulate or embassy to obtain a passport for emergency travel is deemed to have thus re-availed themselves of the protection from the country from which they were fleeing persecution. This leads to a presumption that they are no longer being subject to persecution because they have freely let their old country's authorities know who they are. It is seen as a signal that they no longer fear persecution in the home country, and similarly, that they no longer fear the authorities because they are submitting themselves to the authorities for the purpose of getting a passport or travel document. Similarly, it is a sign in the eyes of the CBSA, or Canada Border Service Agency, that such person intends to return to their country of origin from where they were fleeing persecution. Thus, even applying for a passport from the country from which you were fleeing could lead to what is known as the cessation of one's refugee status. The cessation of refugee status has very grave consequences. They include the removal of the protected person status and the denying of refugee status in Canada. This opens up the ability for the Canada Border Service Agency to move toward deportation after the Refugee Protection Division of the Immigration Refugee Board determines that you have availed yourself of protection by the fact of applying for and receiving of a passport. The cessation process is typically triggered by the Immigration Department or the CBSA acquiring information about your travel or passport acquisition. For example, you may be applying for your Canadian citizenship, and the citizenship authorities may have reviewed your citizenship forms and discovered that you have either applied for and or traveled on a passport to the country from which you were fleeing persecution. This information may be sent by the immigration authorities dealing with your citizenship application to the CBSA. Similarly, you may have obtained a passport from your country of citizenship for the purpose of some grave issue, such as visiting an ailing relative, and in that situation, upon returning to Canada from visiting your sick or dying relative, the CBSA at the airport may discover that you not only obtained a passport from the country, but have actually traveled to that country, albeit for an urgent reason. The CBSA typically does not excuse travel based on the urgent or pressing reason. The CBSA, upon receiving such information, would make an application to the Refugee Protection Division of the Immigration Refugee Board, asking the board for a finding of the cessation of refugee status. This taking away of status may occur despite the fact that you may be economically established in Canada, have family and Canadian children, or have young children in Canada who are studying in a Canadian school. During the process of cessation at the IRB, such humanitarian compassionate factors such as the best interest of a child, or economic establishment in Canada, or family ties to Canada have no relevance whatever to the cessation process, and they do not excuse or mitigate the reason for traveling to the former home country. The loss of protected person or permanent resident status is a finding of the denial of the refugee status. This leads to the inability to work or study in Canada without a work permit, and no appeal against the finding of cessation. But there is the potential for a federal court, which is a review rather than an appeal. Thereafter, the removal from Canada is supposed to be as soon as possible, and in many cases, a humanitarian compassionate application for permanent residency cannot be filed until 1 year after the finding of cessation by the IRB. There would be no other assessment to slow the removal process, such as what is known as a pre-removal risk assessment, or PRA, for 1 year after the finding of cessation. If the immigration authorities or the CBSA have expressed the concern to you about a passport from your country of former residence/persecution, and if cessation proceedings have commenced, or you feel they may be commenced, or if such cessation proceedings have led to the actual finding of cessation, contact Chaudhary Law Office. Thank you.